This is the Circle City News, where we discuss legal stuff. And I am here with Audrey Lunsford, attorney at law. And of course, I am attorney Mark Nicholson. And we're here today to talk to you a little bit about protective orders versus restraining order in Indiana, and also no contact order. So I'm going to let Audrey go ahead and talk about protective orders, because she does a lot of protective orders. I do too. We both do protective orders, no contact orders. But to split it up, she's going to talk about protective orders, and I'm going to talk about no contact orders. So carry it away.
Yeah, I was going to say, and sometimes, there's a little bit of an overlap too. In domestic violence cases specifically, I'm going to focus on protective orders, which is done through the protective order courts. And basically, I would say the most common would be the domestic violence cases. So there's domestic violence cases that will lead to protective orders, and then there's also other types of cases we'll talk about next. But I just wanted to start with, first of all, how to get a protective order. So in order to get a protective order, obviously a lot of people like to hire an attorney. There's some paperwork involved, but generally you need to make specific allegations that include a relationship between a family or household member. And that definition is pretty broad. It allows not only somebody who's currently like a member of your family who lives in your house, but also, and more importantly, dating and previous dating relationships. So an ex-girlfriend that never lived with you, et cetera, et cetera. So that's definitely a very common one. You need to first allege the relationship, and then you need to allege specific facts as to why you're asking for it, specific incidents that happened that are leading you to ask for that. So once you do apply for the protective order, including allegations of that relationship and the incidents that occurred, the judge will receive that protective order and do a couple of things. First of all, they can issue an ex parte order of protection. And that is generally just prohibiting that contact. So stay away from my house, stay away from my school, stay away from my job, don't threaten me, et cetera, et cetera. But just the staying away can be issued ex parte. So that means, of course, Mark, you want to explain ex parte for me while I take a breath here?
Yes, and I will say that I think it's okay for me to say publicly that Audrey is pregnant, and she's going to have a baby, probably in the next few weeks here. Obviously, since she's sitting down, you can't see her stomach, but it is very large because the child is growing inside.
That way they know that I'm not just a heavy breather.
That's right. You're breathing for two people today.
Yes.
So basically, ex parte is an order or an action where it is kind of outside court. It is outside the presence of the other party. So ex parte, if there's two people, you and the opposing party, one of you interacts with the court without the other party being there. And so that's what they call kind of like ex parte, because one of the parties is not present. And normally this would be like a violation of the rules of professional conduct, the rules of the parties or judicial code of conduct would be violated, because the court is not supposed to engage with one party over the other. Ex parte, once again, is kind of these Latin terms that the legal profession likes to use, and basically it means technically, literally, from, out of, the party, a faction of, or done with respects to or in the interest of one side only, or of an interested outside party. So it's kind of just saying that there's one side being heard and not the other side being heard. So for people that don't speak Latin, I'm one of them. You can think of it ex parte, meaning Xing out one party, or as we often say, my ex-boyfriend, ex-wife, ex-husband, means they're no longer a part of your family, your life, or whatever. Well, ex parte, you're Xing out one of the parties. Is that enough
Yeah.
time? Catch your
Yeah,
breath?
that's great. Thank you. And it's important to note too, because they're not having a hearing in front of a judge when this order is issued, that they can only do certain things, and that's usually limiting that contact. And when an ex parte order is issued, I know in Marion County, a lot of judges will just do it for like 30 days and then they'll set a hearing for, the permanent order where parties can present. In other counties, they do it a little bit different. It just depends on the court. But anytime an ex parte order is issued, the other side the respondent can request a hearing to contest that. So if the judge does grant an ex parte order and the other side opposes it, they can simply request a hearing to contest that order. So it's really just a preliminary emergency order, essentially. The court can also do some other things ex parte. Usually that involves possession of a home or possession of an animal. However, if the court does do that, they would require a hearing within 30 days in order to address those sorts of relief that were granted in those situations, which I think is part of the reason Marion County a lot of times will just automatically give you that 30-day hearing, so that if they do anything that the other side might end up filing to contest anyways, it's just already on the calendar. And then some of the bigger ones that people really, infringe more upon their rights, those do require a hearing. So a hearing does need to be held, and a court will schedule for a hearing in certain instances, such as if you're asking for their guns to be taken away. That's obviously a huge one, so that requires a contested hearing. And then one big one in family law, because I do a lot of family law cases, is like parenting time and custody, stuff like that. That can actually be sorted out by that judge, but it does require a hearing. So, for example, if I have a family law case where there's not currently a divorce or custody filed, but one of the parties wants a no contact order, the judge can not only say you two are not to have contact, but I'm going to order visitation, and here's how visitation is going to occur, so that the children are still able to see the other parent, even though there's that no contact order between the parents. Often that'll just include things like meeting at a fire station for exchanges, third parties being present, apps, things like that. But the judge can order those sorts of things in a protective order. And that's pretty common. That's pretty common in, protective orders, but judges do prefer to keep those sorts of things in the family arena if possible. So usually they won't order those for long periods of time. They'll advise the parties to file an actual domestic case, and then they'll try and get those cases in front of the same judge, in front of the same court, so they can address those issues going forward. They won't always extend those as long as a normal protective order. A normal protective order is about 2 years. But in those cases, sometimes they'll just do it for a few months and say, go file for divorce, go file for paternity, get that taken care of. They don't want to hang on to family law contested hearings for very long, but they do have to address those issues where parents can't communicate.
Right. Now, one of the things that is, I think, a little different in Indiana than maybe other states, where people may get this a little bit confused, is what's a restraining order? I've had people say, I want to get a restraining order, or I got a restraining order against this other person. Can you explain what a restraining order is in Indiana, or is there even such a thing?
I was going to say, people ask me that. I sometimes, it catches me a little off guard because there's not, you file a protective order request. So Outside of protection orders and no contact orders, generally the term, in my experience, has been used to kind of describe both, just any act that restrains a person from that contact. But I don't have people actually getting restraining orders.
Yes, that's correct. That's a perfect segue into talking about the no contact order because, yeah, Indiana, there's no legal restraining order. In other states, they may have something called a restraining order instead of calling it a protective order. But in Indiana, we don't have a legal um, title of a restraining order. And I think people do use it interchangeably when they talk about getting a no contact order or getting a protective order. And
yeah, I will just add one more thing before we transition to no contact orders, because I think that a lot of people use restraining orders fairly commonly, in a sense that doesn't include the family or household member definition. And there is a protective order that is allowed for a non-family or household member, and that includes victims of stalking or harassment,
yes,
continued acts of harassment. And so I think a lot of people do use a restraining order kind of in that sense, because you don't have to meet that definition. This person's, harassing me. Can I go get a restraining order? In that sense, it's the same process as far as alleging specific acts, except you need to allege more than one act. And you don't need to meet the definition of family or household member, except I will say in those cases, you cannot get an ex parte order. You skip right past that and you get a hearing within 30 days. So I think often people just kind of use that term broadly, and in the sense of harassment or annoyance or stalking. But I will say I do think it's used often in that sense where you don't have to meet that definition, but it's still a protective order. It's just a different section of the Indiana Code.
yes, that's a very good point. Letting people know that to get a protective order, you don't always have to be the family member or household member. And oftentimes, I represent people on both sides. I've represented people that have filed for a protective order, and I represented people that had to defend that they were considered the respondent in a protective order. So there's been the household family members, there's been the workplace, and then there's also been just the general harassment of the party. So I've seen all sides of the protective order process. I've represented, like I said, both sides of that, filed them, and defended them. Now, moving on to no contact order. The no contact order is basically almost the same thing, except this is really a state action. This is usually something that the state does, and they are only really in criminal cases. So the protective order that we talked about is really civil in nature, like the family law, you're going to civil court, that kind of thing. Doesn't have to be any criminal charges, but you would think in some cases if the acts were bad enough to get a protective order that it could cause a criminal case. Like if the person had battered you, harassed you, there is laws on the books that, prevent people from like stalking and things like that. So a no contact order is in regards to some criminal charges, and then the state files the no contact order. The person that's the complaining witness or the alleged victim in that case can also go and file a civil protective order as well, and they can get a protective order. But the no contact order usually involves victims of domestic violence, where the state will say, I'm charging this person with domestic battery, which is one of the areas I definitely practice in. That's why they call me the battery man. So that is where the state will say, we need a protective order to protect the complaining witness. Robbery, theft, anything that really involves some type of victim in a case, the state can then request a no contact order, unless it's like murder, because the person is deceased, so they wouldn't necessarily file a no contact order in that case. But when you're talking about domestic abuse, violent crimes, sexual crimes, those the state will almost automatically file a no contact order. Although I've seen no contact orders for thefts and things like that, where pointing a firearm at someone, boom, that's no contact order that were issued in those. And there's also something that they have, which is like stay away orders in these criminal cases, where someone shoplifts from a big box store like Walmart. They will issue a stay away order, so you can't go to a Walmart in like Marion County for the next year or so, or you can't go to this specific Walmart for a specific year or 2 years or whatever it is. So that is something else that can arise from a criminal case, is the stay away orders. But those usually deal with businesses, not necessarily an individual. The individual will get a no contact order, and the violation of the no contact order is similar to a violation of a protective order, meaning the person can be held in contempt, they can be thrown in jail, they can be fined, and things like that. So you want to make sure, if there is a no contact order, that you can follow it so you don't get caught up. Now, one of the questions could be, hey, I have a no contact order. It's been issued against me. What can I do about it? So what you can do about it is you can hire an attorney to file a motion to review the no contact order. And the judge usually sets it for a hearing, and then you can present evidence about why it should be lifted, especially in domestic battery type cases where the complaining witness wants to have contact with the accused for various reasons. Maybe the charges are false. She was just mad and lied on the person, or he was mad at her and lied on her and saying that she's the victim, trying to take care of their children, bringing in income. All these kind of things can factor into why they want the no, or they just don't feel threatened, so they want the no contact order removed. The judge will set up for a hearing. You can present evidence, and then the judge may remove it or not. Or maybe it was placed incorrectly, like the prosecutors went overboard and filed a no contact order against the complaining witness, children, all that kind of stuff like that. And it's like, hey, these people shouldn't even be on here to begin with. Now, I'm going to throw that question to you, Audrey. What if someone wants to challenge a protective order?
Well, there's one thing you just mentioned about maybe that person didn't feel threatened. So actually, when they do have those hearings, whether you request a hearing, like I say, you can just request a hearing to challenge an ex parte order. Or, frankly, you can also, if the alleged victim or the petitioner requests for it to be disposed of, you can let the court know, and you just have to file the proper paperwork. But the burden in protective orders is credible threat. So the judge does need to find that there's a credible threat to the petitioner, and if that petitioner changes their mind and says, I don't think I'm feeling threatened anymore, then you can simply file something with the court. Or if there's some circumstances to make, you think that credible threat is no longer present, you can also request a hearing to challenge that. Yeah.
One of the things that you mentioned, like the burden and, saying these are some of the factors I need to find, is like the credible threat. There's, we hear in criminal cases beyond a reasonable doubt. Well, in these civil cases, not necessarily beyond a reasonable doubt, it's by the preponderance of the evidence. So by the preponderance of the evidence, the court has to find that there's a credible threat. And that's the burden that we have to prove. Same thing with this no contact order. They don't have to get in there and prove beyond a reasonable doubt that a no contact order should be put in place, because this isn't, even though it is a criminal case where the no contact order came out of, it's not actually this criminal charge. So you don't have the high burden of beyond a reasonable doubt when it comes to the no contact order. It just goes all the way back to this preponderance of the evidence type of thing. And that's one of the lowest standards there is when it comes to the burdens of proof. So you have the highest, the beyond reasonable doubt, in the middle, clear and convincing, and then at the bottom is a preponderance of evidence. So 51%, and you win.
And that's the interesting thing about those no contact orders is because they only travel with the case. So if the case goes away, the no contact order goes away.
Exactly. Very good point. Yes, if that case gets dismissed, like I would try to do if you hire me and the case gets dismissed, boom, no contact order goes away. However, this can get people tripped up because I've had it happen. They think because that criminal case goes away, they can automatically have contact with the complaining witness. But lo and behold, there is a protective order in place that did not go away. And then now they end up getting a new case for violating, invasion of privacy, for violating the protective order. And that is a whole nother case, criminal case, invasion of privacy, because they violated a protective order or a no contact order, and they get a new case. So
it's a misdemeanor, right?
Yes, and it is a misdemeanor. So you have to be careful and make sure that if you're going to have contact with a person, that there's no protective order and there's the no contact order has been dismissed, because oftentimes, the two parties will want to get together, especially when it's a family situation, boyfriend, girlfriend type, there's children involved. They'll want to get together. Police pull them over for some kind of petty traffic stop, and boom, one of them is charged with violating the court order and goes to jail. And it's just like, why? But that's what the law is. And it only works one way. So if the protective order or no contact order is against you, even if the complaining witness tries to have contact with you, you still cannot, because that's often questioned. But they contacted me. They called me. They came over to my house. Still, you got to run away, stop, don't let him in. Maybe, whatever you do, get away, because you will be the one getting arrested.
See, I was going to touch on that too, especially in these domestic violence cases. With protective orders and no contact orders, a lot of times the other party will come in and they'll say, well, I want the judge to issue a protective order against him. And you actually have to have corresponding petitions and corresponding orders. The judge in one protective order court or the criminal court can't issue no contacts against both of them unless they have jurisdiction over both of them in the criminal case, or there's two petitions in the protective order case. So
Right.
For every protective order, you need one on each side, then you need a petition on each side. For the no contact order, the judge can't say to the alleged victim, I'm ordering you this, because they don't have jurisdiction over that person. So it gets kind of messy, especially in those domestic cases, because sometimes they'll have criminal court will have a no contact order, and then there'll often be a protective order in a different court from the petitioner or the respondent, the plaintiff or the defendant, or both.
That is good. That's a very good point. And it's something that people need to be aware of, because I hear that too. Well, I want to get a protective order against them. I want to get a no contact order against them, whatever, because they're harassing me. And sometimes in my experience, it's like whoever gets there first. So if the one that files it first seems to have the most credibility, and the court will then kind of deny the other party when it tries to get one in place, because they're like, hey, it's already been granted. And also they have to have jurisdiction, but the court that does have jurisdiction often will just smack them down. And I've seen that happen, where we file it and it's just automatically denied without even a hearing, and it's boom, denied. And
to race to the courthouse.
Go ahead.
To race to the courthouse.
Yes, and we say that not literally, because you can file, when it comes to the protective orders, online. There is a place where you can file protective order online, and I'll include it in the information, the little summary, where you can file online for a protective order. You can also obviously go to the courthouse, but I think most of the time that the protective orders are being filed online, and it's a pretty easy. They make it pretty easy process to file online. Although I will say, I think for attorneys to actually file in the protective order cases, they make it more difficult than it has to be, in my opinion. But that's just the way they have it set up. Now, if you are someone that is getting served because there's a protective order or a hearing protective order, I highly encourage you to get an attorney, because you won't really know what the standard is. I mean, this is not legal advice that we're giving you. This is for informational purposes and entertainment. So you can't get in and say, hey, I'll watch this video so I know exactly what to do when I go there. There's a lot of intricacies. There's objections that can be raised, all this kind of stuff that can happen at a protective order hearing that we obviously don't have time to cover. But it is in your best interest that you hire an attorney, whether it's me or Audrey or someone else. Get you an attorney that knows how to handle protective order cases. And obviously, if you have a criminal case and they put the no contact order in there, that's part of it. Hire a criminal defense attorney that knows what they're doing in those type of cases.
And protective order cases are confidential, which is kind of an interesting thing, because it's really hard for people that aren't familiar with that system to know how to file and access those documents, because they're kept in a separate database. Otherwise, I would tell you to go sit in protective order court one day, because it's real interesting. I would say at least 50% of the cases will generally just get reset because of lack of proper service. But if you don't have a case in there, you can't get in. So, because of the confidentiality. But I mean, yeah, it's an interesting arena to be in, and some familiarity is definitely helpful if you're going to proceed in that manner. The misconception, if both sides are pro se, sometimes the judge will give them just a little bit more leniency, but the rules of evidence still apply in protective order hearings, and that includes hearsay. That includes getting documents in. That includes everything that generally you would want a lawyer there for. Like I said, sometimes if both parties are pro se and the other side's not objecting, sometimes the judge will let things in, but the rules of evidence do actually apply in protective order hearings. And so that's important to remember. If you're like, well, why were they allowed to talk about all this stuff? Well, you didn't make the proper objection. I'm sorry.
And pro se means what?
Not having a lawyer.
All right, exactly. Yes, and that is true. So representing yourself is going pro se. When Audrey was talking about going pro se, or both parties are pro se, that means that both parties did not have an attorney. Yeah. In most cases, if one of the parties has an attorney, they're going to be better prepared than the person that does not have an attorney. In most cases, yeah. So
yeah, and like you said, in criminal defense cases, that's your attorney that you'll have due to the no contact order. But in protective order court, I would say some people have lawyers, some people don't. I think it definitely depends on your judge, your case, and your evidence. So
that's right. Awesome.
I think one thing I haven't talked about that I just want to touch on is juvenile matters, because I like to talk about juvenile court. Most of a significant portion of my background has been in the juvenile court. So juvenile courts, I would say, are more akin to the criminal no contact order, except we don't have the no contact order forms. We don't have the service of it. Basically, in juvenile court, pretty much anytime you get arrested, they're going to automatically order you to not have any contact with anybody you got arrested with, sometimes the witnesses that are there, and all of the victims, and the place that you were at when it occurred, if it's like a robbery or a theft, like you said, like a stay away order. But instead of having these formal orders, it's just a condition of your release, and then it's a condition of your probation. So they do often order in those juvenile matters these no contacts and these stayaways, but it's just I guess it's a little bit less formal, because they're rules of your release, the rules of your probation. But they can also, just like in the no contact orders in criminal case, if you violate them, that's a violation of release or violation of probation, and they can lock you up for those sorts of things. And that applies again to any juvenile matter, especially when there are multiple people involved, not just the victims, but the co-respondents, which is akin to co-defendants.
Awesome. Awesome. That's really good information. Well, before we end this episode, I think that we are very thankful for Audrey, who obviously has a lot going on inside of her. So we're very thankful for her to spend her Saturday with us and explaining some of the things about juvenile law, which I have very little experience with, and also the protective order process, and also me talking about the no contact orders and a little bit about stay away orders. So we're very thankful for that. We're also thankful that this will be made on various platforms, the YouTube, we're posted on Facebook, it'll be on social media so people can watch it, reshare it, like it, or whatever the thing is, heart it, whatever that is, to show that you like these. And so we look forward to doing more of these. And if you have questions, email us, call us, so that way we can maybe bring up that topic. Like, we got a lot of people asking about a certain thing, and we can bring up that topic and kind of address it in this platform and put that information out there for free for anyone to watch at any time. So
thanks
until
for
next
having me, Mark.
Oh, it's a pleasure. I'm glad you're with us, and I look forward to doing many more with you, Audrey. All righty.
Bye, guys.
Bye.